Good evening, everybody, and welcome yet again to another Dear South Africa live stream. And tonight's quite an anticipated one because our guest, Stuart Hayward, he did a really thorough analysis of the implications of this unlawful entry bill. His video on the Centre of Risk Analysis, we had a chat to David on Sora, that is linked in the video description above or below, depending upon which platform you're watching this on. Specific good evening to Jane, good evening to everybody else. Stuart is running late, and I suspect that he may be caught in something, traffic or otherwise. So we're just going to give him a couple of minutes chance to get in here. Worst case scenario, if the streaming deities don't want us to have this discussion tonight, I will try and wait a second. No. I'm holding it too soon. Here's the man himself, Stuart.
Gideon.
I don't know if you can hear me loud and clear, but I can.
Yeah, I can. I'm just adjusting my camera just to make sure. I have this horrible habit of having my head cut off the whole time.
Well, hopefully not in real life. We can deal with that.
Yeah, that's better. No, it's just sometimes in my videos I don't even realize that I have a bloody head cut off. Yeah.
Well, Stuart, it's fantastic to see you, and we had a very productive discussion on the phone this afternoon about this topic. So, you know, I'm going to just dive right in. I already kind of gave everyone a brief hello and intro, but just tell us a little bit about yourself, your background, who you are, and then we're going to just dive right in straight to the talk about the topic at hand.
So I'm an advocate at the Joburg Bar. I've been practicing for 10 years. So for those that maybe don't understand the distinction, an attorney is somebody that briefs an advocate to go to court. Attorneys deal with general law, sort of like wills, contracts. They also go to court, but not very often. Advocates go to court for attorneys, and we specialize in dispute resolution. So we get called in. We're basically a hired gun to argue a matter on behalf of a client by an attorney. So my expertise is very much in dispute resolution, and I spend day upon day looking at legislation, interpreting case law, arguing in court, preparing heads of argument for court. So my perspective is very practical in terms of when I look at this bill, I look at what the act will look like if the bill is passed as an act in Parliament. And that's where I am extremely concerned, because I've seen a lot of toing and froing on social media, not even social media, just in the sort of mainstream media about this bill and how it's all just a cacophony. It's just there's no don't be alarmist. There's nothing wrong. We need to change from the Trespassing Act because it was apartheid legislation, etc. And I think the mistake that a lot of these journalists are making, and that the public, I think, are making, is that they're getting seduced by this preface in the bill to the fact that the Trespassing Act is apartheid era legislation, and because it's apartheid era legislation, then it cannot be congruent with our constitutional dispensation. Which means that so it's the same old weapon used by the political left, and the ANC is leaning more and more to the left as they start losing their majority. So this is not surprising. So we must look at this bill, and I talk about the preface. It's just a justification. It's a never-ending justification of a liberation party that's losing power. So if you want to pass legislation which fits your agenda, always rely on the great victory of the past, which is defeating apartheid. And it's just totally absurd, because the Trespassing Act, the only problem I see with the Trespassing Act is or maybe I'm jumping the gun here. Maybe I should just sort of let me just break this down more simply, and let me deal with that later on. I think the where we must start, Gideon, is that this bill. So this bill was gazetted by the Minister of Justice and Constitutional Development. Okay, this is the facts. Now, before that bill can be tabled in Parliament, the minister must consider public comments. Okay, so, and I just to kind of simplify this, it's similar to the situation under COVID where there were regulations gazetted, but these are not these are not regulations. This is this is a bill which will become an act if it remains as is. So in many respects, whilst regulations are law and they inform law, and ministers have a legislative function there, this is a statute on the books. So in many respects, this is the gravity of this act is much far higher than a regulation which can be done away with by the swipe of a pen.
I was about to say, amending an act once it's in law or repealing it is about as lengthy a process as getting a new bill passed.
Absolutely. No, you need a majority in Parliament. It needs to be tabled. It's a process. So you need so this is the danger with bad bills, and bad bills are vague bills where there's uncertainty and there's absurdity. So this is in many respects a lot more serious than the COVID regulations. Of course, because regulations can, like I said, be done away with, and that's what happened with the COVID regulations. But it's not that simple with legislation, and you make a great point there. So we're dealing now with legislation. Now, legislation is really, let's just talk about what that is. So in law, we have the common law, which is a body of law that is uncodified. Okay, in South Africa, and that is a mixture of Roman Dutch law and British common law. Okay, that's the South African legal system. Just very basics there, very basic. In there's a trend globally to over-codify. Okay, so it's this growing state, and as governments lean more to the left, they become bigger, generally speaking. I mean, that's not always. Some governments that lead to the right also like big government, but it tends to be a trend sort of towards the more socialist, leftist governments, where the common law is no longer good enough anymore. We must codify. And the codification is really just a setting in stone of the common law. Okay, but the absurdity is that there's no need for it. For example, there are many common law crimes which don't, sort of like common law trespass. There's actually really no need for a trespass act, just to give you an example. So there's common law trespass. Okay, you're breaking into someone's property.
Well, I was about to say murder is an offense. There's no murder act.
Yes, sorry, that's a great example. So yes, 100%. So murder is your great example of a common law crime. There's no act that says that murder is a crime, but it wouldn't surprise me if governments start to, there was a murder act. But you see, the problem comes in when you codify something.
Please no, let's rather not ever do that.
But that's exactly the point, because what you're doing when you codify is it's number one, it's unnecessary, because we have the common law, we have the case law that's interpreted the common law for hundreds of years. So it's unnecessary, number one. Number two, if you codify the common law incorrectly, then you are effectively doing away with years and years of precedent, because the legislation will inform the way the case law will inform how you interpret the legislation, but the legislation will prevail. Yeah. So there's a huge danger in over legislating, and the ANC government is massively guilty of this. So generally what governments do is they codify to more to suit a political agenda than because it assists anybody. Like, and that's what I think I'd like the public to understand, that this is much more than just a bill which is deals with entry onto your property, and why should you be worried about that? I mean, for goodness sake, it's more about for me, a question of sending a message to government that the public is not going to stand for this pervasive leaning to the left. And you can see it in the legislation that you're making this absurd obligations on landowners to inform, duties to inform, giving would-be criminals absurd defenses to get off. And so, yes, technically speaking, these are all something, and I'll get into the meat of the bill now. But I think that there's a general theme when I look at of that agenda that's being pushed by government. And it's no coincidence that it's coming at a time when the ANC is losing power, and it suits them to become even more extremist. And so the public must look at this not as just a silly act that will have no application in their lives potentially because it won't be enforced, but you have to send a message to government and the importance of commenting on legislation, because even if the minister ignores the comments, which he may well, I mean, he may or he may not. There are organizations like DearSA that use those comments for purposes of a court review, because the minister has ignored comments, and we saw that with COVID. So what DearSA did, it took the comments and it challenged the government for its failure to do away with COVID regulations because it totally ignored the comments. And there's no coincidence that government gave up the ghost, and that application never even proceeded. So that is the work and the power of commenting, and I think the public doesn't understand that. So there's a bigger picture here.
You're preaching to me, and fortunately everyone in viewing, and this is a powerful statement to it, because, and I'm just going to use this as an opportunity to remind people that comments on this close on the 16th of September. That's next week, Friday.
Yeah.
The link to that campaign is also in the description of this video. You can click on it to go comment on the unlawful entry bill. Up until now, there's about 6,423 comments, which isn't bad. We always prefer quality over quantity, but please, if you have not, go use what Stuart is talking to us about this evening. Incorporate that, even if you just write a paragraph or a couple of sentences, and go comment on this bill. Also, I'm going to just do the usual YouTube thing that makes me vomit a bit. Please like, subscribe, and share this video, as well as the campaign. Thank you very much in advance for that. But Stuart, I think very important here is previous discussions about this kind of circled around how vague the contents of the proposed bill is, with specific concerns about the implications for property owners pertaining their property rights, and reserving right to admission and that sort of stuff, which I'd like you to maybe expand upon regarding your viewpoint. But then equally so, the implications for people exercising their rights to private defense in the event of them confronting, for example, someone that they encounter trespassing on their property. Because this, correct me if I'm wrong, but does this have the implication to, or the potential to have impact on other pieces of legislation as well, like the Criminal Procedure Act and how it's interpreted? Yes,
no, without question, with the Criminal Procedure Act. I think, Gideon, if I can maybe answer your question just by sort of starting off with a very like nuts and bolts example of the problems I have with the bill. And the public must remember, when I talk about the bill, I'm really talking about a prospective act. So I'm talking, let's talk about, let's call it the act, because that's really what it is. This is the problem. It's not an act yet, but it will be an act if we don't comment enough. So this is the problem I have with this, the Unlawful Entry Act, okay, as it stands right now, when it becomes an act. So I think, and this is where my practical experience as a courtroom lawyer makes a big difference in my viewpoint. A lot of the views I've seen have been coming from lawyers that are not, they're potentially attorneys, they're people in the security industry, and they're all having comments, and they're making comments which are, in my view, are not practically guided. I run criminal trials regularly, and 99% of criminal trials start off in the magistrate's court. This is the engine room of criminal law. And magistrates, unlike a high court judge, are what we refer to in law as creatures of statute. They do not have a discretion in applying or not applying legislation. So high court judges, in contradistinction, have an inherent discretion to enforce legislation or not, if there is some sort of overwhelming factor which so they are bound by precedent from the Supreme Court of Appeal and a full bench and the Constitutional Court, but they are not necessarily obliged to follow a statute. If there are circumstances which allow for not following the statute, they have that discretion. Magistrates don't have that discretion. Okay, now that's the starting point. So the engine room of criminal law is the magistrate's court. So if somebody is, so let me give you a practical example of what I'm talking about. Okay, so any and every thief or intended thief, somebody that is coming onto your property, intending to housebreak, intending to commit violence against the owners and tenants of the property, necessarily trespasses or intrudes before they commit their crime. Okay, I think that's obvious. Well, I mean, perhaps it's not that obvious. I think maybe this is the problem, is that there's a lack of understanding of just how of where the elements of the crime fall in. So they need to breach a boundary wall. They need to walk into a gate. They need to trespass before they evince an intention to thieve. Okay. So let's use an example and this is just one example in the bill, which is just absurd. Okay. Section 3.5 of the Act, the bill, okay, states, and I just want to read it, just because it's worth reading, because this is just how absurd it is.
No, please do.
There is a presumption that access for lawful purposes to the door of a building on premises by a means apparently provided and used for the purpose of access is not prohibited. And the heading of this section 3 is that unlawful entry on premises is prohibited. Okay. So the bill has this premise that unlawful entry is prohibited. So there's this sort of the red herring. Oh, well, everything's fine, you know, because this is not consistent with the Trespass Act because unlawful entry is prohibited. But then there's this section 3.5, which says, and I just want to unpack this, is so the question is, what is a presumption? Well, a presumption really means that they're not committing an unlawful entry if they enter the premises through a door which is commonly used as an access point, and if they do so for a lawful purpose. So all that the the person at a criminal trial would need to do in refutation of the state's case is say, well, that's a garage door that's used for access, and I was looking for a job.
Yeah.
So you leave the garage door open. You've taken your shopping inside, and there's a passerby. The passerby looks around, and security companies will tell you this, that the majority of break-ins happen opportunistically. So these people are generally not armed because they're not ready. They didn't plan an attack. So they basically it's a situation where the passerby walks to your garage door, and then what happens is you come out. So they didn't see you leave, so they think maybe the door's just open, so they're not sure if someone's home. But what this does is incentivizes somebody to take a chance. Okay, now that is putting the public at immense risk. Now you come out with to collect the rest of your groceries, and there you find this intruder. That intruder stands there, and who knows what, it gets a fright. Okay, that intruder gets a fright. That intruder is there on the basis that he knows that if he is caught by security or by the owner, he can just claim he was looking for a job because the door was open. So it's incentivizing an extremely risky situation. And I don't need to elaborate on what could possibly go wrong when that person gets a fright. So there the public is already exposed in a massive way. Now, there was a comment by somebody on the stream about the fact that this is shifting the onus of proof.
Yes.
That's not necessarily true. And I'll tell you why, is because in criminal trials, the onus is always on the onus is always on the prosecutor to prove that prove the offense. But what it does is I don't agree that it shifts the onus, but it shifts an evidential burden, which is not the same thing as an onus. An onus is the state prosecution, the prosecutor must prove the crime beyond a reasonable doubt. What this does is that it gives so the prosecutor will in this case charge the individual for unlawful entry, and will try and prosecute, and it will put its case forward, and once it has put forward a prima facie case, the unlawful enterer will not need to prove that their entry was lawful, and that the entry was not prohibited, so long as they can prove that they were there for a lawful purpose and entered through a garage door, which is used as an access point. So it makes it easier for a defense lawyer to refute the prima facie case put up by the prosecution. Okay, so that means that once again we're talking about incentives here. And it's just one of these situations where it's just too easy to say that you're looking for a job. Now in situations where someone is not home, what's that intruder going to do? Let's say somebody forgot their garage door open, or the electric fence just opened. I mean, the electric gate just opened. It was there's something, it's malfunctioning, and somebody came inside, and of course now you're incentivizing, making it easier for someone to go in and steal, and then they'll just fleece you and just rob you blind. So there they've committed a crime. Okay, right. So that is one of the situations which one of the absurdities.
So by essentially, to summarize in very plain language, there is very little consequence for somebody walking around your garden without your knowledge, if they could easily gain access to it from a main entrance.
Yeah, if you are human and you forget, which we all are,
yeah,
and if your security company forgets to close the gate, who knows? I mean, these things happen all the time. We know obviously crime is we prioritize locking up, but sometimes you're busy unloading something. I don't know. It happens like this. That the incentive is just there to go and take a look, and then that most likely that person could run away if the owner comes with their shopping, and they'll run maybe most of the time they'll run away because the chance wasn't worth it. Okay, fair enough. And then they won't get caught because the police do nothing anyway. We know that. I mean, I hate to say that, but it's just the truth. But what about the situation where that person reacts aggressively? Now you're putting somebody in harm's way. Whereas now let's compare that situation to the Trespass Act. Okay, so it's important that we understand, that we understand what's being changed. Okay, so this bill or act will repeal the Trespass Act. Now the Trespass Act says, the Trespass Act is one of the most beautifully simple and clear pieces of legislation, I think, on a statute book. And it basically says that there's a prohibition of entry or presence upon land and entry of presence in buildings in certain circumstances. Sections 1.1, any person who without the permission, section 1.1a, of the lawful occupier of any land or any building or part of a building, or 1.1b, of the owner or person in charge of any land or any building or part of a building is not lawfully occupied by any person, enters or is upon such land, or enters or is in such a building or parts of a building, shall be guilty of an offense unless he has lawful reason to enter to be upon such land or enter to be in such building or parts of a building. So he has to have a lawful reason to enter, not a lawful purpose, but a lawful reason to enter, which is different, because a lawful reason is I got permission to look for a job, and now I'm on your property. But a lawful purpose is, well, I'm looking for a job. You see, that's where the problems come in, and so that's what this bill is trying to amend, to do away So you're giving more and more opportunities for defenses, just making a prosecutor's job even harder than it already is, because you have to prove beyond a reasonable doubt, which is a stiff burden of proof, in the sense that
there's something that bothers me or concerns me even a bit more, Stuart, is apart from that rather concerning gap in the legislation, or rather its shift of burden, or rather, it's a shift of burden of who's responsible for keeping the trespasser out, essentially. What implication or impact would this have, or consequences rather, would this have for the property owner in the event of a trespass happening? Because I think there was very little clarity on that section of the bill as well.
So in the event of a trespass, just maybe be more specific. What do you?
So let's say someone is trespassing on your property right now,
Right.
under the provisions of this proposed act.
Right.
What implications does it hold for you, and has there been any significant changes there as well?
No, so the bill states that unlawful entry is an offence. So section 3(1) says every person who unlawfully enters a premises commits the offence of unlawful entry. Okay. Now that's all good and well. Okay, so that's the foundation. But the problem is it's the defenses that are available for totally absurd reasons. Now maybe I must just add a bit of balance to this discussion, because I think we must be careful of just being just not sitting on one side the entire time. If there's one part of the Trespass Act that I think should be amended, it's that intent is not a factor in whether you can be prosecuted for trespassing. Okay. Now there's situations where, if you look at, say, the rural KZN, rural Eastern Cape, where someone is collecting water, there's no boundary line. Maybe the river is a boundary. There's no fence, and they cross over, and they didn't know that it was the farmer's land. They had no idea. They could be arrested for trespassing. So that's where the intent of the person should, and that's where the Trespass Act should probably be amended to say, if there's no fence, if there's no clear demarcation, and someone genuinely didn't know that the property was owned by somebody else, then that could be a defense, and I think that would be reasonable, and that would be constitutional. I think, because the South African, we're looking at low literacy levels, low levels of education, formal education at least. So I think that, and Gideon, the totally crazy thing is that this act doesn't even address that.
I don't recall reading anything along those lines. No,
what it does is the defenses are available to somebody. If you look at section 9 of the act, a person may not be convicted of an offense under this act if the person's action or inaction as applicable to the offense was with the consent of a lawful, section 9C, if they reasonably believe that they had title to or an interest in the premises that entitled them to enter the premises. So somebody who's an illiterate cow herder, they are not going to have be able to say, I've got an interest. They're just fetching water. I mean, for goodness sake. So that's the absurdity there. So this act doesn't even address that. Probably the only issue within the Trespass Act. But in truth be told, the Trespass Act as it stands, it's very unlikely that a prosecutor is going to prosecute somebody who clearly had no intention of being there and was arrested. So there's a little bit of humanity that comes into this, and there's clearly a discretion. But I think that's an important thing to raise now, is that legislation, in my view, considering the fact that magistrates are creatures of statute, and you may get prosecutors that are trying to make a name for themselves, should be protecting against the most ignorant and the most arrogant and condescending magistrate or prosecutor, in my opinion. So we need to chisel this if we accept the fact that this act is going to be passed, perhaps that's nothing we can do about the fact that it'll be passed. It must then be chiseled into a form that makes it as idiot-proof as possible.
So
if that makes
sense. There was another section of it that kind of bugged me a bit, and there's two parts to this. I'll quickly read it and explain my concerns, and then maybe Stuart, if you don't mind, maybe unpacking it. Sure. The one is section 7, which is obviously duty to inform the intruder of unlawful entry, which section 7(1), as soon as it comes to the attention of the lawful occupier of the premises or an authorized person, they must request the intruder or intruders unlawfully on the premises to leave the premises immediately. And then 7(2), if the intruder or intruders does not leave the premises, or the lawful occupier or person authorized by them are threatened in any manner, the lawful occupier or authorized person must, without delay, request assistance from the authorized member, which seems a bit grammatically incorrect, of the South African Police Service as contemplated in section 8(1), informing them of unlawful entry, the address of the premises, and the approximate number of intruders. And this then flows into section 8(1), or rather section 8, rather, where they, in 8(1)(a), define what an authorized member is, and 8(1)(b), if they're not available. But then it gets to 8(2), 8(3), and 8(4), which, as soon as an authorized member or members are informed of unlawful entry, they must, without delay, which is important, go to the premises to remove the intruders. Section 8(3) says, on arrival, an authorized member must call upon the intruders to leave the premises by obtaining their attention and in a loud voice order the participants to disperse, and so on and so forth. They will be arrested. And then 8(4), which could either be good or bad. This may be an improvement on the Trespass Act, I'm not sure, is if the intruders already erected any form of housing on the premises and already occupy the erected housing, the authorized member or members must arrest them for unlawful entry on premises, which I think if I had to come up with something that may potentially be a positive, it might be only that specific section. I think it's 8(4), that kind of gives the police slightly better powers to deal with trespassers that have already started unlawful occupation.
Yeah. So let's just start with section 8(4). Yeah. Look, there has been okay. No. So section 8(4) is, I think, was included because police have been reticent to do anything about people erecting informal housing without a court order. Okay, that's why I think section 8(4) has been included in there, and I think section 8(4) is worded in a way which protects the unlawful occupiers' PI rights, Prevention of Illegal Eviction Act rights not to be evicted. So if you look at section 8(3). That allows for the police to not only arrest, but also ask persons to leave. But the moment they've erected any form of housing, then they can't, the implication is they can't ask them to, they can arrest them, but they can't ask them to leave because they have a right in terms of the PI Act. It doesn't say that, but I think that is why. So, Helen, I agree with you. That's possibly the only sensible addition here. But I think that, so maybe I must just,
there's an additional point of concern tied into that, is there's specific mention of the South African Police Service. Now, in the real practical sense, we know that the average response time of the SAPS is measured in minutes, and even in the best performing areas of the country, you're looking at an average between 30 minutes and 2 hours that it takes the police to arrive, and that's average. I mean, in some cases, it takes them multiple hours if they ever arrive at all, and I think there were a large proportion of national call-outs where the police never arrived on scene. So it's all good and well for the act to say they must, without delay, which is why I emphasize this, do something, but practically that's highly unlikely to happen in practice. The other part of this is I don't know if it limits the rights of the lawful occupier or owner to actually sort of rely on the powers of citizens arrest, or security companies relying on the powers of citizens arrest to act there.
This is the most controversial aspect of this bill, which I don't think it should be. I think it's a huge problem, but I think the biggest problem is that it generally incentivizes people to take a look. But this is a huge problem for people in the suburbs who have security companies that rely on Section 43 of the Criminal Procedure Act to use a citizen's arrest and take the intruders to the police, who then arrest them formally. And then people that aren't fortunate enough to live in the suburbs with security companies, the question then is, can they arrest an unlawful intruder? Okay, so this is a big problem, of course, because like you say, the SAPS is massively problematic. But even if the SAPS wasn't as incompetent as it is, anywhere in the world, you needed a right to use a citizen's arrest, because there's just no ways. Even the best police force in the world, police service in the world, is never going to be, a minute. It's just not it's not feasible. So the fact that the SAPS is incompetent, of course, is I think we can take judicial notice of that in the legal sense. But the problem here is that so if I look at this logically, I say, well, is this Section 43 right to use a citizen's arrest usurped by this act? And now, like logic would tell you, probably not, because Section 43 is the Criminal Procedure Act. It's the overarching. It's what a magistrate relies on. It's the magistrate's Bible in a criminal trial. It is a codified procedure for criminal trials. Okay, so but now you need to look. This is where the public needs to take a bit of time and look more closely at these Sections 7 and 8. Now, what struck me is that there's a very specific procedure that's set out in Section 8, at Section 7 and 8, which speaks about we're not talking about just the landowner must inform the SAPS, which maybe that could be expected. It's an authorized member of the SAPS. So this is somebody that is trained to deal with this. That's how I read Section 8. So we're talking about steps that must be followed. For example, as soon as an authorized member or members are informed of it, they must without delay go to the premises. On arrival, an authorized member must call upon the intruders to leave the premises by obtaining their attention in a loud voice, etc., etc. So when I look at this, I think, how would a magistrate interpret this? Why is there a very prescribed formal procedure that must be followed? And why is there such respect given for people that have already erected housing? I think that's because of the PI Act, but also because those police, it's not just any policeman that can come and arrest an intruder. There's a procedure that must be followed. So that leads me to believe that a lay person who's not a trained policeman cannot effect this arrest. So the more I read the act, the more I think perhaps Section 43 is usurped. But Gideon, the important thing here is there are people that will say to me, don't be absurd. Section 43 will always apply, But whether I'm right or wrong, the vagueness and ambiguity is a massive problem.
Yeah.
Because if one person gets off scot-free, gets acquitted on the basis that a security company arrested them, and let's say there's no high court precedent that the magistrate can follow, what is the magistrate to do in the situation? You've got potentially, this act doesn't say that they can't citizens arrest, but if you look at the wording of the act, there's no discretion here. No. That they must contact, they're obliged to contact the SAPS. These are very strong words. So this is a situation where the public should comment on this, but they must comment with substance about this absurdity in terms of the following. Now, if you look at Section 8, it's not very technical, what the police must do. But why would there be this prescribed procedure if it could just be an ordinary policeman you could understand? So it is incredibly vague. There needs to be some chiseling done, and so that again, that's the point. And I must comment on some of the social media the viewpoints from security companies.
Please do.
I'm absolutely flabbergasted I saw something on ENCA. I couldn't believe it. They interviewed a gentleman that was supposedly apparently he's a security expert, and he basically said that this act was great. It's just the security industry's been waiting for this, and I just thought, what bill has he been reading? But this is the problem there, that he's not a lawyer, clearly, and he's never run a criminal trial. He doesn't understand how magistrates would interpret this, and
there's a couple of other things about this, Stuart, and it's the fact that what would concern me about this is potentially in Section 7 and Section 8, if a property owner or a responding member of the SAPS do not follow the prescripts of this act almost to the letter, there's probably a very good chance of them compromising the opportunities to successfully prosecute or convict a trespasser of this crime, because all that I'd assume the defense has to argue is, well, my client was never informed that he was trespassing, or he wasn't informed in a suitable manner. 100%. And the police were never contacted. He was removed by private security. Therefore, it's very, very prescriptive.
100%, 100%. And if you're going to codify, here we come again to bad legislating. If you're going to codify procedure, that's all very well, but then you must codify the procedure correctly, so that a magistrate that doesn't perhaps know doesn't perhaps know the common law very well could then be guided. But here, this is clearly not a codification at all, but I could only call it some, and we come back to iconoclasm, this metaphorical iconoclasm, in the sense that we must break down the structures of apartheid. And I find it ironic that an act must be passed which does away with which is more constitutional, but that act just gives would-be thieves more rights. So possibly that is constitutional, but I look at the Trespass Act, I don't see, to be honest, anything unconstitutional besides what I raised about the incentive. I mean, the lack of provision for intent, but that's questionable as to whether that's unconstitutional. So yes, Gideon, you're right. This business of informing the intruder, there's nothing in the act, the bill, about the ramifications of failing to inform. But there again, and this is something that I raised in my CRA video, is if you don't inform the intruder, it seems to me that there's a possibility, like you say, that they could just claim that as a sort of a technical defense. Well, I didn't know. But the most ridiculous thing is, if you look at Section 7.2, is that there's by implication a duty to give the intruder an opportunity to leave the premises, which is just like, I mean, if nothing else in this bill, if everything else in this bill is great in your eyes, then Section 7.2, just if it doesn't give you a problem, then I don't know. The concept of giving somebody an opportunity to leave the premises, it's laughable, Gideon. I'm sorry.
So I'm just going to bring people's attention to Section 42 of the Criminal Procedures Act. That
43.
An ordinary member of the public has the right or privilege, well, probably the right, to enact or effect a citizen's arrest for any Schedule 1 offence that is committed in their presence. So, which includes trespassing, by the way. That doesn't mean you have to give the trespasser who's committed the offence the opportunity to leave. You can actually, if you so want, put your hand on them and inform them that they're under arrest, and then hand them over to a police officer without delay. So how this would actually interact with that, and I think, Stuart, as we come to the tail end of the conversation, I might ask you to just summarize, and then I'll say my bit as well. But what's important here is that when legislation is this vague, regardless of our sentiments about it, and I think one of the key things of public participation is we really want to enhance the quality of laws that are passed, if the public wants them passed in the first place. and that we have seen many success stories. We're actually busy compiling a list of previous DearSA success stories about where the organization has had an impact on either getting undesirable legislation shelved or having it amended to a point where the public was happy with it. It's very important for people to comment on this and register that they are unhappy with certain sections of it or the business in its entirety before the 16th of September, which is next week, Friday. Yeah. And I'm just going to put the link up on the screen. So sorry, Stuart, over to you. Just maybe
big picture overview. Before I do that, there was a comment about from one of the viewers just about the putting up of a sign, and it's something that should be addressed. Just very briefly, so Section 3.3 by implication states that there should be a sign because the warning can be orally or in writing. So this is also a huge problem. In what language must that sign be? What happens if the intruder is illiterate? This is just like what happens if the sign is not illuminated? Or the sign is stolen,
or if you're trying to secure a fairly large piece of real estate, how many signs must you put up, and at what sort of degree of intervals would be sufficient?
Yeah, I mean, you would think that if there's a fence, an electric fence, that it's pretty obvious that it's private property. But so this is something that needs to be commented on. There, you don't have to put up a fence. A sign. You can warn orally, but in practice, of course, so that you don't have to wake up at 3 o'clock in the morning and tell your would-be thief, "Oh, by the way, you're intruding." I'm laughing because it's just so absurd. That's the only. I just think that it tickles me, actually. I mean, if you don't laugh, you'll cry. That the minister actually thinks that bill is possible as an act. And there was actually a social media, the Minister of Justice, Constitutional Development, Mr. Lamola, put up I think it was a TikTok video about the fact that there's so many rumors that your right to self-defense is impacted by this. And he's right, it's not impacted by this. But you see, there again, that's smoke and mirrors. Yes, of course you can still defend yourself. No one's saying you can't, but you're just incentivizing people to come onto a property and put you in that situation where you will have to use self-defense. So the minister, again, is just totally reckless. For someone, he's got legal advisors. It's just actually frankly dishonest and misleading. Now, just in summation, Gideon, the public just. Maybe hopefully this.
So just to tell,
a summation of the difference of the old act and the new. Okay, maybe I should do that just to respond to the viewer's comment. I think. Look, I've already gone over what the Trespass Act is. It's just really very simple. If you don't have someone's permission to be on their premises, and if you're not there for a lawful reason, you are trespassing. And then you are guilty of the statutory crime of trespassing. Okay, it's very, very simple. It's about 3 sections. This act states that does away with the statutory crime of trespassing and introduces an unlawful entry statutory crime. Okay, so, and this crime also states that you are an unlawful entrer if you are there on someone else's property without permission and without a lawful reason. So in that sense, it is in line with the Trespass Act. But the problem with this act is that there are a whole lot of crazy defenses that a trespasser, i.e. a would-be thief, that's the important thing that the public must understand. Someone is trespassing for a reason. They're not trespassing to pick your roses.
If we look at trio crimes and other confrontational crime statistics, I think let's not make bones about this. A potential murderer or home robber,
absolutely,
a violent one,
absolutely. So it's not just to say, oh, trespassing is just so arbitrary, I can still defend myself. They're not there to pick your roses. They're there to steal from you, to rape and pillage. Like, let's just be frank here. We live in an incredibly violent country. So that in itself is what makes this Mr. Lamola's statement just so ridiculously absurd. So in summation, the minister has just gone too far with a ridiculous. It's not even. I wouldn't even say it's an over-codification, because this was never part of the common law. This is just introducing a whole lot of procedure that has never been part of the common law. So this goes beyond codification. There's a socio-political agenda at play here, and this is now, when you look at the expropriation bill, the ANC is moving to the left. There's no doubt about it. This act doesn't surprise me in the slightest, because we need to do away with the oppression of apartheid by giving, basically, we're actually just looking to curry favor with voters that would like to actually just have a look to see if they can steal something. I mean, isn't that the message they're sending? It's just totally ridiculous.
It's potentially a worse message than that. And I think if you look at it in the big picture of the erosion of private property rights, which 100%. Is something we saw in East Asia in the 1950s and 60s. We saw it in South America during the same Cold War era. And it's unfortunately something that left-leaning political parties the world over are very much in love with. As a private citizen, not as a person of Dear South Africa, as a private citizen, something like that would concern me, because we understand how important private property rights is for wealth, for freedom, for security, for all the good stuff that we would want and need as a country. And that would be something that I'd be concerned about. But Stuart, we've gotten so many good comments about your contributions here this evening. I think we would love to have you on again. People, if you'd like us to have Stuart on again, please put it in the comments or send us a mail. Stuart, tell us a little bit, where can people find you? Where can they find your writings? Where can they find your other videos? I mean, for those who have just joined us, Stuart's previous chat on the Center for Risk Analysis is linked in the video description, so please go watch that one as well. But Stuart, where can people find you?
So they can find me on the Johannesburg Bar website, which is a bar. The Bar Association is an association of advocates, where all of my contact details can be found. I can also, perhaps Gideon, I should just send you a link to all of those. I also have my group of advocates website that they can find me on, where I have a profile. They can also find me on LinkedIn. I will send you those links, if that's okay. So it's easy for people to, and the public is more than welcome to contact me if they need any clarification. If I can help them to understand why I have the problems that I have. And advocates we're not permitted to take instruction from the public, legal instruction, but in this capacity, I welcome a discussion, and to just, maybe if someone doesn't understand something, because it's important that people comment with substance. Don't just go onto the DearSA page and just say I'm against the bill and leave the blank the reasoning, because the more substance you put into your as a comment, the more ammunition you are giving NGOs like DearSA to use a PAJA review, which is a court application to review the minister's decision to table the bill in Parliament, right? Later on. So it all matters. Even if your comments are ignored, you're giving DearSA not only the fact that you are against the bill, but you're giving them proper comment. And if that comment is ignored, the more substance that comment has, the harder it is for the minister to ignore the comment. So take the time, please. And I'm very much available to assist. I'm passionate about helping people understand the importance of preserving democracy, because South Africa, and this is something I said in my video before, and I need to say it again. South Africa is the only country in Africa where we still have participated democracy. And I think a lot of people don't appreciate this. And when I talk about participated democracy, I'm not talking about just a democracy on paper, which is what we see in pretty much every other African state, where there are elections. They may be free, they may be fair, they probably aren't, they're probably rigged, but there's participation on. It's all about democracy is a facade of legitimacy. in those countries. In other words, it's a way for the West and donors to feel good about donating to rogue states. That there's on paper there's a parliament, which we all know is totally meaningless. Look at Zimbabwe with Mnangagwa. And if South African citizens do not participate by commenting on legislation, it's not just about going to vote every 4 years and every 2 years. Every 5 years and every 2 years and every 3 years. It's about participating in democracy. You need to comment. It's so important. If you don't participate, that's exactly what because I can tell you now, the governing parties is quite happy for you not to comment, because they'd just like to get their way. They'd like to use their majority to pass this bill. They'd like no ammunition for court reviews. So if you don't look after your democratic right to comment, you lose your democracy. Our democracy is incredibly fragile. We know this. So antipathy, public antipathy, is totally unacceptable. It takes you literally 2 or 3 minutes to go onto the DearSA website and put your comment in there. You can use any one of my comments about this section or that section. Please comment with substance. It can take you 5 minutes of your life, and it really makes a difference.
Stuart, that is probably the most resounding vote of confidence I think I've heard for our organization in a long time. So thank you very much for that. And I think you summarize and you encapsulate my own frustration sometimes with the process beautifully. And you kind of stole my line, because this is exactly everything I wanted to say. You kind of have that already.
Gideon, sorry, it's something we said in our phone discussion is a lot of people don't understand what happens when there's a comment. DearSA sending an email to the minister. Maybe explain that. I think that's really important.
So folks, your comment doesn't just end up in the ether. When you comment on DearSA and you hit send, that comment is put into an email format, an officially recognized and accepted email format, and it's sent to the originator. In this case, it is the Minister of, I think, Justice and Correctional Services or something.
Minister of Justice and Constitutional Development. That's Minister Lamola. Yeah.
It goes straight to Lamola's office, to the email address as stipulated on the notice calling for public comment. All that we do is we keep a copy of your comment. We make sure we track it to make sure it ends up where it's supposed to go. We can see if it's opened, if it's deleted without being read, if it's opened and then deleted, whatever's done with it, or if it's never opened at all. We count all the comments individually, so we can keep track in live of the amount of comments that have gone through, and we can put together a full summary at the end of the campaign that explains how many people were for a proposal, how many were against it, and how many were on the fence, and what their comments and concerns were. And we can make all those comments, which will be anonymous. It's only first names, but the full comments are also available to be read. So there's complete transparency. So when you
compare, sorry, Gideon, if you compare that to somebody sending an email on their own at their own instance and saying, I don't want to use DearSA, I want to send my own email. The ramifications of that is that the minister can just ignore your email, and DearSA doesn't have the information, doesn't have the statistics, the ammunition to then use a court challenge for the lack of considering that comment. That's important that the public understand that. Why must you use DearSA? Because you're collating information, you're giving an NGO invaluable information. So when you use what a Pudja review is, you are reviewing the decision taken by an organ of state. And that is an incredibly powerful piece of legislation. But if the public doesn't comment through the correct channel, which is somewhere, because otherwise we don't know how many comments. The minister might say, oh, there were actually 10,000 emails when in fact there were 30,000. We have no way of knowing that. So that's why DearSA that's why I'm such a big fan of DearSA, because it gives the public an ability to comment easily without hassle. But number two, it gives DearSA that ability, exactly like what happened with COVID, with the COVID regulations. So this to me, as a lawyer that has performed a couple of Pudja review applications, I wish I had that kind of evidence to perform my review. So that's, I think, important for the public to understand.
So, and on that invitation, and I'm going to be like Jeremy Clarkson as we've just run out of time, and on that bombshell, folks, comments close on 16 September. That is next week, Friday, 5 p.m. Please go find the unlawful entry bill. There is the URL. It's linked in the video description above or below, depending upon which platform you're watching this on. Go and have your say. Use what Stuart said here tonight. I know it's been an hour-long discussion, but there have been so many good sound bites and impactful, good information. I think, Stuart, thank you that you've disseminated here this evening. Just take a few lines of that and populate a paragraph, because your voice will, and not can, it will make a difference. And Stuart, from I think everyone on our team from the viewer side, thank you for taking this hour out of your Wednesday night to really unpack the concerns about a very vague and confusing piece of proposed legislation. And I would love to have you back on here for some other discussions when it suits you, if you're okay with that. Consider this a live on-air invite.
Thank you, Gideon. Well, let's see if your viewers want me back. I don't want to be presumptuous.
I'm pretty sure they're gonna. It's been very well received. So folks, thank you for tuning in. And so this is asking for another platform. I'm probably going to do one this Friday on my channel, so do tune in. But folks, thank you. Have a safe evening. Please go comment, and see you on this channel again next week about something entirely different. Have a safe evening. Thank you, and